Immigration policy changes every day. Careers, businesses, and families are all at risk. You need to stay informed. We can help. Welcome to this week's episode of the Immigration Podcast.
Well, you can always edit that part out.
Yeah. All right. Hello.
Yeah, 'cause
This
look at me,
is
I
Rob
just froze.
Ratliff, and with me today again is
Susan Hiller,
hey, and
how are you, Rob?
good. And this is actually our double-digit episode 10 of our
Awesome.
immigration podcast, and it's just me and Susan today. But lots of interesting things going on in the immigration world. So first thing, we've all got the notice: 25 temporary immigration judges, all
Yes.
with military backgrounds, all with JAG Corps. And what was shocking to me, there was 11 immigration judges appointed full-time, and then the 25 temporaries. It was, I don't remember the exact number, but it was about 85% men, which is very rare for the immigration judge appointments. It's usually
I
50.
didn't count it, but I mean, I kind of think it was like 99% men.
It could have been. It could have been. There's a couple names I wasn't sure.
And I'm not against men, but I've always said that one of the things that I thought, because I've had 26 years experience with immigration, I started out in this before people were ever interested in it. That, becoming an immigration judge, for example, when they started adding in the veterans preference, that's wonderful for the veterans. But when you go on a scale of the percentage of women that are veterans versus men, the military, it's generally going to be, you're not going to get a fair demographic.
Yeah. Well, and I can remember, like, when I first started pursuing an immigration judge position versus when I finally got appointed, probably 5, 6, 7 year period there. But even when I first started paying attention to that, you seen more and more women becoming appointed in those positions, and it became almost all men to slightly more women, and because there's more women attorneys now, more women in the population overall. So it started matching that 55%, 60%. And it was, very, very clear that was the trend. But this was, it was so shocking to see. It was just almost all men. I mean, there's a few names like I wasn't sure of, but
I think there was like maybe 2 women.
yeah. So very, very different perspective. And with all the military judges, 25 of them are all military judges or military JAG Corps officers, and now they're judges. And I don't.
Yeah, and there's another problem with that. Well, of course, we'll get into the legal aspect of it. But Rob, let me ask you a question. If you're coming from a country where women are being persecuted by rape or any type of sexual torture, how comfortable would you? I don't know if you have a daughter, but if you had a daughter,
Yeah.
how comfortable do you think your daughter would be in front of a male military judge? Or I mean, JAG is, they're still in the military field discussing that.
Well, that's a very interesting point, and I really don't know the answer to it. Do you know whether they're going to wear the black robe or they're going to be in uniform? Because in a military tribunal, they're in uniform.
Ooh, that would be very.
It would be very boring to walk in and
I
see
would have.
the medal.
I came from a place that is basically a military dictatorship, or I was abused by somebody in the military in my country. That would be a lot of post-traumatic stress.
Yeah, I would assume, because the EOIR rules are you have to wear the black robe, and but I don't know. I haven't heard, and I guess I need to look into that, because that could be an important issue for some of our clients. When they first announced it, I thought, there could be two sides to this, because some of these JAG Corps officers are going to have significant firsthand experience in some of the most horrible countries that we see clients from. They're going to know, when the client's there, they're talking about the conditions in their country. Some of these people are going to have real experience and say, yeah, I know exactly what it's like for you there. And that could be good, but if they're under orders to do one thing and it's not grant asylum, that obviously has a whole different impact. I don't know how independent they can be if they're under orders.
Well, yeah. I mean, how can they not be under orders?
Exactly.
Who do they work for?
Exactly.
They work for the U.S. military, and they are under. If they do anything wrong, they can be court-martialed into a military tribunal, right?
Yeah, yeah, and and that raises one of the legal issues, and I know there's one. We'll start with there. I mean, the Posse Comitatus Act, which is one that I think all immigration lawyers are talking about and objecting to the jurisdiction of these people as immigration judges. And Posse Comitatus Act basically says you can't deploy U.S. military on U.S. soil against citizens and residents and things like that. So it's an interesting question, and I think one jurisdictionally that's definitely got to be raised. And
Well,
are you looking into doing those?
yeah, actually, the Carolinas, AILA Carolinas, actually is going to come up with a standard actual motion to recuse all of these temporary JAG military judges under Posse Comitatus, because the problem that you have, like you mentioned, is they have orders. I mean, the military is a quasi dictatorship because it has to be, in the sense of when they're out in the battlefield, you must follow the commanding leader. So when you don't follow orders, of course, lawful orders, but when you don't follow orders, you can be court-martialed for that. So here, there's still JAG officers have to follow orders. The orders are probably to get these. I don't know that we'll ever see this in writing, but let's say they call them enemy combatants. The way that the political appointees and such forth are acting like we're being invaded by an alien enemy. And if they're military, if they're considering them as invading forces, invading people, then they're instructed to treat them that way. Then, and we can go into the fact that they really don't know the immigration laws and how complex they are.
Yeah.
But let's say even if they did, but their orders are to deny all asylum, and just basically to deny everything and order people removed very quickly. Then what other choice do they have? They could go to jail if they don't follow orders.
Yeah, and lose their military career, and that's the thing. We'll never know as defense attorneys or an immigrant going into court. We'll never know, does that person have some conflicting order with deciding my case, and that's one of the things that I think the Posse Comitatus jurisdictional argument, I think, is important and something that will be addressed in the courts and needs to be preserved, because as we know, the rules are going to change. I mean, they change every time the administration changes. But I think on a country by country basis, you have some real significant issues. It's in the news every day that we're blowing up drug boats from Venezuela, and we're talking about.
Like, are we?
Yeah, yeah. So we're talking about regime change.
Are they really drug boats?
Well, who knows? But assuming that they are, we're in this state where we've got a leader of a country that we've declared head of a terrorist organization. We're in essentially open conflict where the military is blowing up their boats. So now I've got a client whose TPS was just terminated from Venezuela, and you're going to take that client into immigration court, and it's going to be heard by a military officer who's actively engaged, or our military is actively engaged in operations against that country. I don't know how that all plays out, and how as a military attorney and temporary immigration judge, you're going to resolve those various conflicts.
Yeah, that's a really good point. And then it also brings in ethical conflicts. Like who is your duty? Well, of course, your duty is your oath to the Constitution, but in that particular case, you still have commander in chief, What is the mission? What are the mission needs? They're conflicting. And going back to your earlier point, because I thought that was really interesting too, I thought about it for a second too, how we won't know what the military orders are with these JAG individuals or military judges, whichever it is that are coming. And if we try to FOIA it, Freedom of Information Act, they're going to say that it's military confidential. Like they're going to basically put it under DOD. Mm-hmm. And yet, I mean, that's the whole problem right there is we can't have due process.
Yeah.
If we're being put into, you're really actually taking, I think, the immigrants and putting them, they're making it seem like they're taking the JAG people and putting them into immigration court. But I really feel like they're taking the immigrants and putting them into military court.
Yeah. And I, obviously, I think that's the goal. I mean, I think this administration, I think many administrations in the past even have flirted with that issue of, taking, putting this into almost a military tribunal. That was one of the issues with the Guantanamo detainees,
right?
We put them in military tribunals. So, but there are numerous countries throughout the world where our military is actively engaged. So what is the issue there? And then there are many places where our military is actively engaged that we don't know about. You 20 years from now, we'll watch a movie about, SEAL Team 6 doing something in some country. So if the military is actively involved in a specific country, and now we're talking about asylum or some other relief for a person from that country,
Plus, we need their help.
Yeah.
We might need their help. Like it's actually can jeopardize the military's mission if the military is seen as hostile over here to them, but the U.S. military needs those civilians' help back in that country, in that operation. We now are strategically undermining our own operation for the military in that country.
Yeah.
And
with
that's far worse danger to America or American personnel, officers, stationed overseas than this one person having temporary protected status in the United States.
Yeah, and with earlier this year, the designation of many of the cartels in Central and South America as foreign terrorist organizations, and I don't really have too much problem with that. In fact, I think many of those organizations probably deserve it. But now we're in a situation where we have people claiming asylum from those countries. We can take a client into court, and that military judge can say, no, you're not qualified for asylum because you're affiliated with this foreign terrorist organization. Much, I just did a case out of Cincinnati, right, where those issues were coming up. And we have no way to know. Right. DOD has all this information. They're blowing up drug boats coming from Venezuela based on their information that these are drug boats, not fishing boats or anything else. And if we take them at their word that they have secret information that these are cartel affiliated, how then are they going to rule in an immigration case and maybe on that very issue? Is this person related to or provided material support for this foreign terrorist organization? I'm going to obviously argue, if the facts are that my client did not, and we'll present the evidence that our client did not or is not providing material support to a foreign terrorist organization, the judge could simply come back and say, well, I have information that you don't, and they are, and they're denied.
Okay, well, that presents another issue. Now the judge becomes also a witness in the case. So, and where is he getting his information from? From classified information that we can't review or contest? And can we have the maker of the document come testify and question them? Because, there are, again, taking the DOD at its word, these are drug boats, right? But at the same time, you can't, as an attorney for the respondent, you have to look at all the angles. You have to know, first of all, where did they get this information to connect your client to this organization?
Yeah.
because, is the information they're relying on accurate? I mean, obviously with Iraq, we went in for chemical weapons, right? We all know later on what that actually was. I actually knew it before because my brother was in Kuwait ready to go into Iraq, and they were told there are no weapons of mass destruction, so don't worry about me. But in this particular case, some of this stuff that the military engages in is actually, propaganda for their reasons, whether we like it or not, false flags, whatever it is. They have a reason, a strategic reason of why they want to go in, maybe to Venezuela, maybe for the oil reserves. They may know why the United States needs X, Y, and Z to survive. They're ahead of the game in things we don't know. Mm-hmm. And all we know is we have a client in front of us and we need to come to the truth for this particular client. They have a whole different mission. It really does have propaganda. It's part of their operations, definitely propaganda. And which part is the propaganda and which part isn't?
Yeah, and how can we ever verify some of that information? And again, going back to the Cincinnati case, we were fortunate that we uncovered documents that were able to show that what the government had said was not true. We may now, with military judges, we may be in a situation where they make that you're not entitled to see this information.
Yeah,
and you're out of here. So
now, do you think they'd be able to? Again, I really feel like they're going to try to stretch this as much as possible and put us into a military court as opposed to they're in an immigration court, which is why we have to make sure we challenge every one of them with the motions on the posse comitatus. And but if they try to make it the other way, then are they going to try to subject us, U.S. citizens? This is the part that's really worrisome too, to military tribunals, because we're not listening to the judge. But let's say the judge is doing something incorrectly and we're being respectful and we're respectfully opposing something because we have to, create a record. Trying to think of a scenario where the judge says, you're not doing that and you're going to follow orders.
Yeah, it's an interesting situation, and you see it play out, kind of on the street level with police and sometimes with ICE now. When a police officer tells you to step back or step away, is that a lawful police order? You're getting in the way of somebody having an emergency situation or something. Yeah, oftentimes those are lawful orders and you should comply and you have a duty to comply. And if you don't, you can get arrested for obstruction or disorderly conduct or any of those sorts of things. But sometimes those aren't lawful orders and you don't necessarily know until after the fact. So now you've got a military officer, saying, step back, what is our obligation in some of those cases? It's going to be tricky. It's going to create some interesting legal issues.
Yeah, I think if we all stick together and stick on that posse comitatus and really just make it difficult for the administration to bring in military judges into an immigration, a civil, administrative violation.
Yeah.
Some of these people might have just overstayed their visa, and really it does not require military officers in there. And again, some of them have been to Afghanistan, some of them have been to some of these countries, some of them haven't been to these countries. They may be new JAG officers.
Yeah.
They have no training, not the type of training we have in immigration law.
Right.
And immigration law is like the tax code. You can understand one section, but if you don't understand the history of how that section intertwined with another section, you're not going to be understanding it correctly.
Yeah, and that's an interesting thing, because you and I have been doing this about the same number of years, and a lot of times I'll meet with a new potential client who may have went and seen 2 or 3 other immigration attorneys, and we'll go back and look at their case and we'll talk to them about things that might have happened in the 90s or early 2000s in their case and say, well, based on all these things, you have this option now. I'm like, well, nobody told me about that. Well, part of it is just the history of it,
Right.
and it's tough to keep up with all that. And it's very, very difficult. So, and I think one of the most important things for all these individuals, when you have that military judge and whatever judge, you've got to preserve all the issues, because we know no matter what the rules are today, no matter what the courts rule tomorrow, 10 years from now, it's all going to be different.
Correct.
And if you've preserved the issue, the biggest example of that was back in criminal cases, when the sentencing guidelines,
I
remember the
see.
sentencing guidelines were mandatory, and all those
Oh,
people,
yes.
yeah, and all those people just, okay, it's mandatory. But then when all of a sudden it wasn't mandatory anymore, and all those people were found to have waived that issue.
And 212C. And then we also have where convictions for drug trafficking, all you had to have the word is drug trafficking in the criminal statute. And now we analyze the actual statute to see if it's drug trafficking by possession
Yeah,
or, so things do change. And
you just got to preserve those objections.
you want to hear something exciting though? I did find out.
Definitely.
Again, and not that I agree with I don't agree with the way that DHS is actually saying expedited removal and the parole because of the way that it is in the act, but also the way we taught it at the Federal Law Enforcement Training Center to the officers and agents for over 20 years. But I was in a master calendar the other day. This is a public, for those of you who don't know, this was a public hearing. Anyone can actually join in on these as long as we're not discussing anything private, then it would be closed off. But the government attorney in Charlotte, the assistant chief counsel, and she's been around for a long time, she said to another attorney, he wanted to get a 601. He wanted to close the proceedings to get a 601A provisional waiver. And she said, counsel, you don't need to do that anymore. She came in illegally. She was paroled, and the assistant chief immigration judge is on the stand right now for this particular immigration judge. So she was the judge, and she said, well, you didn't check that box off, DHS counsel, on the notice to appear. It doesn't say, it says that they were not admitted or paroled.
Right.
And the assistant chief counsel said, irrespective of what that box says, she was paroled for purposes of the Immigration Act. And because of that, she can adjust her status, but only, this is what they said. I don't know how they get around this part, there's nothing that says that, but only in immigration court, not in front of USCIS. So the parole, apparently they want to, it's for their detention thing. It's that whole for expedite removal.
Yeah.
They want to consider when you're paroled out of custody, no matter where, that you are now paroled, so you could be a mandatory detention. So this is their argument, remember, on that I can follow their logic on that. But if they want to adjust status of somebody who came in EWI, enter without inspection, and they're in immigration court because they want to consider them paroled when they were paroled out of custody, and they want to use that definition of parole as the same type of parole that you would need, right? Then to adjust status, then so be it. I'm going to reopen. I'm going to make sure all my ducks are in a row. But once I have an approved I-130 for a particular person, I'm going to move to reopen to adjust status in immigration court.
Are they saying that you still need to pursue the waiver in immigration court?
You don't need a 601A anymore.
Really?
She actually said you do not need to go, and she's one of the most strict for relief purposes, assistant chief counsels in the Charlotte office. She said you don't have to go overseas. You don't need to counselor process. That is because of the way that they have to do that, because the way they're using the definition of parole for their purposes of locking people up, it's the same definition of parole they needed to be the same definition of parole for purposes of adjustment of status. It has to meet that same definition. So they're willing to give that up in order to get the detention part. So I'm willing to take their relief part.
Yeah, because the number of people that's going to qualify for are pretty slim. Although
a lot of them already did PD. They did prosecutorial discretion. They're not in proceedings.
Yeah. Well, I can think of one client I have right now who would qualify right away.
And then you don't have to administrate. She was saying, don't administratively close it. Get your 485, your medical, get everything together, and we'll do the adjustment in court.
We should write a blog article about that.
Yes.
Yeah. and talking about that statute. It's interesting. But,
it's funny because remember that spousal thing that Biden was trying to do before he left, and then Trump shut down?
Parole in place.
Well, this is actually the same thing, but almost better. It's like 245I coming back.
See, if they would bring 245I back, it would solve so
But it is, but only if you're in immigration court. Now, I think we should challenge it with USCIS because a parole for purposes of immigration court is the same thing with USCIS. And they are the Department of Homeland Security attorneys.
Yeah.
Remember that. Right. So we represent, when I was the Department of Homeland Security federal prosecutor, I represented both USCIS and ICE and CBP. All the cases filtered into removal proceedings. So if I am the Department of Homeland Security Assistant Chief Counsel, and I am saying that the parole is a parole for purposes of adjustment of status, it is the same with USCIS. We just have to, all the AILA attorneys need to push it because they cannot say, oh, it only for here, but not for here.
Well, that's why I asked. Did they mean that you had to do it through the waiver in court? Because then in court, then the waiver would be available. But
which waiver are you talking about?
Well, for the unlawful presence, if they were seeking the waiver there, but if
they weren't saying you don't need the I-601A, a provisional waiver.
Yeah, so if they're considering it parole, then it should qualify.
They're saying you're paroled, so you don't need a waiver because if you're paroled, you're not accruing the unlawful presence.
In any specific type of parole, were they limiting it to, or
just when they were released from custody? Wow. They want a new definition for it so that they can lock people up. So that same definition, they're using that definition, so they have to in court say you can adjust status. So that's the same thing though for out of court. I think USCIS is going to have to give into it, or they have to give up their argument on parole for detention purposes.
Yeah,
they can't have it both ways.
Well, they want to be able to do the mandatory detention for everybody that entered without inspection.
So now we can adjust status. I look at it as 245I has come back without coming back. Yeah. They're giving it to us, so use it.
We're gonna have to.
That's pretty huge. Like, is it going to take work to get USCIS to do it? For the next 2 years, yes. But if they're giving that argument up and assuming we have, free and fair elections and there is a new administration in a couple years, then, I can't imagine it being any more strict than this administration. But they would have to by then, because there will also be district court litigation, they're going to have to by then, USCIS is going to have to give in.
Were they agreeable then that person wasn't necessarily subject to mandatory detention as well then, right?
Well, this was online. It was an internet hearing. The client was online, so they couldn't. I mean, the attorney was with the client in the office, so they weren't discussing that about the mandatory detention. Okay. He was just saying that he wanted. I think he had an approved I-130. It was a marriage case, and he said that he wants time. He wants to get the case administratively closed to file for the provisional waiver, and that's when the assistant chief counsel went into kind of lecturing him. But in any event, she basically said, "No, you do not. You can adjust status in court
based on the parole."
Yeah,
we're gonna fill up the court. We've got quite a few people in that line, I think.
There's a lot of people.
Yeah.
And there's cases you can reopen. I would just make sure that it's obviously no marriage fraud, nothing, because then you're going to,
Yeah.
but as long as it's a clean case, why not reopen it? Because if it's a clean case and they have to adjust their status, then go for it.
Yeah, no, I think that's going to give a lot of options for some people, because a lot of people just like you said, they were taking the voluntary departure, or just taking the stability removal orders to get out and try to come back. So that's going to be extremely helpful.
Yeah, they're scared.
Yeah.
But I always say, and I've told this to people who come to me after I left the government, is what I've seen over the last 26 years, and if you count since I was an intern, 30 years, that the people who stay the course, just stay the course, obviously don't go into committing fraud. Fraud sticks with you forever. But if you stay the course, you can get your status adjusted. It's a long process. But I've had people come to me where attorneys have told them that, something was voluntary departure, it was voluntary return. They didn't understand what happened in the 1990s. But what I'm saying is, always, if you're watching this and you're an immigrant, always go out and get, additional legal advice. It's like getting another doctor's opinion. And there are ways that you could try to, get yourself legalized. We don't have as many options in the United States as I would like, but stay the course. Stay the course.
That I think clients and potential clients and people that come to see us, I think they focus too much on the now, and a lot of times they just, how can I get to the work authorization? How can I survive the next 6 months or a year? And really, you have to look at these cases in
long term,
almost in decades. 4, 5, 10 years is the path, and not tomorrow.
Maybe 10 years. It's definitely not. I've told clients, it's not like ordering from Amazon. This is not. You're not going to have Amazon Prime, so it's not coming in the mail tomorrow. Under any administration, definitely not under this administration. It's a process. It's a long process. But if you're patient and
do the right things,
just be a patient American, and which is a little bit contradictory, I know, but that's the new way. Patient American, and you will stay the course.
No, I think that's
long process, but it's worth it.
I think that's huge. So I mean, so if you're listening and you were paroled, you detained briefly at the border and paroled, go talk to your attorney.
Yeah, you may not even know you were paroled, because it's illegal. It's illegal. It's almost like a legal fiction in a sense. It's just it's an act that happened. You don't know. You were let out of custody.
Yeah, and that's important, because sometimes that detention, what counts as detention, might have only been 15 minutes. Here's some paperwork, sign this.
Exactly.
Come back and see us. So detention is very broad for that. Yeah, get your paperwork and go see your attorney.
Exactly.
Yeah. All right. Well, Susan, good to see you again.
Good to see you again, Rob.
We'll do another one next week, and we'll shame Anas and Nora into coming back on with us. And
yes, definitely. Yeah, and I'd love to hear next week too, if you have any experience with the new fees and paying the fees. Because I'm a little, everything's new every day, so it's like a new.
Yeah, and
you have to learn.
You have to wake up and check your alerts every morning to see what's changed the night before. It makes it very difficult to plan cases and plan for what to do. And for clients and immigrants, the stress that this is causing, it's got to be really, 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 really tough time. So
yeah.
All right, we'll see you next week.
See you next week.
See ya.
Bye.